Thank you very much. I hope everybody enjoyed your meal. And it's time to move on with our program. You'll notice on our agenda that for lunch today, we're going to have the first annual Clara Barton lecture. Now, what's significant about that, and very important to us, is that earlier today you will recall that I recognized one of the founding sponsors for the Jackson Center in the Frederick K. Cox Center. But this time, I get to recognize a new sponsor to the International Dialogues, and a sponsor that we're hoping to have a very fruitful relationship with in the future, but that is with the American Red Cross. And the American Red Cross is sponsoring today's lecture, and of course has joined us as a sponsor of the International Humanitarian Dialogues. So, with that, I'm going to call to the front Jennifer Carana. Jennifer, as she comes up this way, let me see, there she is. As she comes up this way, Jennifer is the manager of the International Humanitarian Law Dissemination Unit at the American Red Cross. But Jennifer is certainly not new to the work that we do and to the work that we're recognizing at the International Humanitarian Dialogues. And that is that she's worked for, it looks like about 6 years at the International Criminal Court. First in the pretrial division, and then as the External Relations Advisor to the President of the ICC. So I would like to welcome Jennifer, and she will introduce our guest speaker. Thank you.
Ladies and gentlemen, thanks very much, and a big thank you to the Jackson Center and to the Chautauqua Institution for extending the invitation this year to the American Red Cross. As has been mentioned, it's our first year sponsoring the Clara Barton Lecture, but will certainly not be the last. And what a fitting year to be able to introduce such a pioneer of international criminal justice as Ambassador David Scheffer. Before turning to introduce Ambassador Scheffer, I'll just say a few words very briefly about the American Red Cross and our connection to IHL, and also about the legacy of Clara Barton, which this lecture honors. Now, many people in thinking of the American Red Cross associate us with blood, floods, and first aid, but not immediately with international humanitarian law. And so we're often asked, what's the connection? People know about the ICRC and the work of the movement in armed conflict, but what does the American Red Cross have to do with IHL? And in fact, it is part of our congressional charter, it's part of our mandate and our mission to help the American government fulfill its obligations to disseminate IHL under the Geneva Conventions. And while the Department of Defense and the military train the armed forces and service members, we're in charge of educating the American public, the broader American public, all 300 and some million of you, about IHL. So it's no small order, to say the least. And we do that through lectures, training programs, public education activities. Many of you in the room have been friends of the program and speakers for us. And indeed events such as the one here today that help to get dialogue and discussion going about how the laws of IHL are not simply laws that apply on a battlefield in a situation on the other side of the world, but are relevant to all of us here in the United States and any country in the world as members of the international community, and perhaps more importantly, as well as informed citizens, as informed voters, and in the case of young people, as future policymakers, military leaders, perhaps presidents one day. And so we see that role as one that's particularly important, and indeed so in a country as large as the United States with such a large presence internationally. And I was struck by Ambassador Carell's comments this morning in discussing some practices that we would see as violations of IHL, and thinking about, he mentioned the importance of education, and indeed we see that as well. There was a survey conducted in 2011 on the 150th anniversary of the start of the American Civil War, which revealed, perhaps surprisingly or unsurprisingly, that about 50% of the American public had ever heard of the Geneva Conventions or the laws of armed conflict. But when you look at that statistic for young people, it goes down to about 1 in 5 or 20%. And Drew's class this morning was a great example of youth who are really engaged, and we're thrilled about that as well. But obviously there's still a good deal of work to be done given the importance of that next generation in informing those policy decisions along the road. So thank you again for the opportunity. Just a few words about Clara Barton. Obviously, her legacy as a real pioneer, as the first international law girl as well, is extensive. So I will only touch upon a few highlights to turn things over to Ambassador Scheffer. But as many of you know, in 1861, she found herself in Washington, D.C., working for the U.S. Patents Office. And at the start of the American Civil War, rather than fleeing or being a bystander to the conflict unfolding and engulfing the nation, she decided to face things head on and petitioned leaders, officials, authorities to gain access to the battlefield and to provide medical assistance and care on the necessities of life to those who were wounded and sick on the battlefield, irrespective of their allegiance. And that her efforts were widely praised and really earned her the name that many of you know as Angel of the Battlefield. And now again, Clara Barton embodies that spirit of not just working abroad or at home, but bringing those lessons together. So at the end of the Civil War, she traveled to Europe. She learned of the writings and teachings of Henri Dunant, who later went on to found, of course, the International Committee of the Red Cross and the Red Cross movement, and decided to go home and advocated strongly in this country for the U.S. government to ratify the treaty. I guess ratification of international treaties and resistance to that kind of thing is not a new phenomenon in this country. So even then, she faced some resistance, but did prevail, and obviously the U.S. government ratified the treaty as well in 1882. A year earlier, of course, she founded the American Red Cross, which today provides relief services and first aid to millions of Americans and international citizens as well, both here in the United States and abroad. So it's only fitting when talking about a pioneer of international humanitarian law and of humanitarianism to speak about Ambassador Scheffer. And, you know, really, what can I tell the majority of you in the room about Ambassador Scheffer that you don't already know, as people who've worked with him in setting up these tribunals that are represented here today, that all of us as young lawyers benefited from in being part of those efforts. And so I will, however, say a few highlights from his legacy for those who have not worked directly with Ambassador Scheffer or weren't players in those very developments of the tribunals. So Ambassador Scheffer is currently the Mayer Brown Robert Hellman Professor of Law at Northwestern University Law School, where he teaches, among other subjects, international human rights law and international criminal law, in addition to being the director of the Center for International Human Rights. He's also the UN Secretary General's special expert on the UN assistance to the Khmer Rouge trials. Prior to teaching, he was, of course, the US's first ambassador at large for war crimes from 1997 until 2001. In this position, he played an influential role in the creation of the tribunals we see here today, including for former Yugoslavia and Rwanda, the Special Court for Sierra Leone, the Hybrid International Court in Cambodia, as well as the special courts in Kosovo and East Timor. Throughout his tenure as ambassador, he led the U.S. delegation to the UN negotiations on the ICC, including the Rome Conference in 1998. Ambassador Scheffer has also served as the senior advisor and counsel to the U.S. Permanent Representative to the United Nations, has worked as an advisor to Secretary of State Madeleine Albright, and as a consultant to the U.S. House of Representatives Committee on Foreign Affairs, in addition to holding numerous positions in private practice and law firms, the NGO world, and think tanks in D.C. and elsewhere. Ambassador Scheffer's work is obviously both remarkable and inspiring, and I'm very privileged to be able to introduce Ambassador Scheffer. I did also want to mention, for those who are students of international criminal law or who haven't yet had the chance, he's also author of All the Missing Souls, which is really his insider's account to building the international tribunals. And I think what's great about this is that it's not only an academic description of the legal frameworks and how to set up the tribunals, but is really a frank discussion as well from someone on the inside of the challenges that were faced. And that kind of honesty, I think, is very interesting to read from an outsider's perspective. It is also available here at the dialogues outside the room, so please feel free to take a look as well. Ambassador Scheffer, thank you very much.
Thank you, Jennifer, very much, and I'm just so gratified to be here. I want to say that I have the privilege quite often to speak at the American Red Cross International Humanitarian Law study sessions that are held all the time around this country, particularly in Chicago. And I enjoy it very much. I will say that it would be nice someday to get an invitation to one of these that does not ask me to show up at 8:30 a.m. on Sunday morning to teach the class. That would be tremendous. But thank you, Jennifer, very, very much for that invitation, or for that introduction. And I also want to congratulate Jim Johnson on his assuming the presidency of the Robert H. Jackson Center. On my first visit to the court in Freetown, Jim couldn't have been a more gracious host to me, along with Desmond De Silva and others, and I've never forgotten that. I am very gratified to deliver the first annual Clara Barton Lecture, and I want to thank the American Red Cross and all of the institutions that are sponsoring the International Humanitarian Law Dialogues for the 6th year. It is indeed humbling, almost frightening, to be addressing such a distinguished audience of the highest officials of the tribunals and my wise colleagues in the Legal Academy. In light of why we have gathered this year, I particularly want to acknowledge the presence of so many veterans of the Court for Sierra Leone, including David Crane, Sir Desmond De Silva, Brenda Hollis, Stephen Rapp, and Robert Petit. But whenever I'm in the same room as Sharif Bassiouni, Judge Hans-Peter Kahl, William Chabas, Michael Scharf, Layla Sadat, Diane Aman, Michael Newton, John Barrett, and so many others of you, I know I am in the land of the titans in this profession. I especially want to thank David Crane for his leadership and dedication to this endeavor. And congratulations, David, on your chairmanship of the Board of Directors of the Robert H. Jackson Center. David visited me in my office in New York City in 2002 as he was deploying to Sierra Leone. He wanted, like the true professional that he is, to know everything he could about the origins and constitutional structure of the Special Court for Sierra Leone. So over a long afternoon talk, we waded into the past. And then he flew east across the Atlantic to make history. Just one small caveat. I speak strictly in my personal capacity today, and nothing I say should be associated with the UN or the UN Secretary General. Some of my remarks today are drawn from my book, All the Missing Souls. I wrote a chapter entitled Freetown is Burning about this entire exercise of creating the Special Court for Sierra Leone, and you will find much detail there, including how I engaged with Sierra Leone and the atrocities swamping that nation in 1998, 1999, and early 2000 before the tribunal negotiating exercise began. By the time negotiations commenced in May 2000 on the creation of the Special Court for Sierra Leone, there had already been intensive negotiations and tribunal building exercises for the International Criminal Tribunals for the former Yugoslavia and Rwanda, for the International Criminal Court, and indeed for the extraordinary chambers in the courts of Cambodia. Most of the heavy lifting for the latter, the Cambodian tribunal, had been accomplished, including the aspect of there being a domestic court tied to the United Nations through a treaty arrangement. Thus, we had many templates with which to examine and learn from by that stage. So the 5 major war crimes tribunals that emerged from the 1990s, so of those, the Special Court for Sierra Leone was the last one to be conceived and then negotiated during the last 8 months of 2000 and into early 2001. The real start point for the Special Court occurred in early May 2000, and it was not triggered by atrocities against civilians in Sierra Leone, for that had been raging for years in the Civil War. The horrors were bountiful enough, many times over, to merit the creation of a war crimes tribunal sooner than later. But the trigger occurred in early May 2000 with the kidnapping of hundreds of UN peacekeepers by the Revolutionary United Front, which had renounced the flawed Lomé peacefire of 1999. The UN force commander had spread out his troops in small groups in various parts of the country, and that made them vulnerable, especially for purposes of rescue in the aftermath of a kidnapping. Meanwhile, atrocities picked up in the northern sector of Sierra Leone, and there were reports that Foda Sanko, the head of the Revolutionary United Front, had ordered his troops to invade Freetown again. In the State Department, Harold Koh, then the Assistant Secretary of State for Human Rights, and I determined the time had finally arrived in Sierra Leone to consider some serious options for accountability. We knew we had some wind in our sails due to the outrage in New York over the kidnapping of the UN peacekeepers. There were years of atrocities in Sierra Leone to build upon for the rationale of a tribunal of some character, so the crime base was not that difficult to map out. And to his credit, Coe was on top of doing so with his staff. By May 10, 2000, I briefed my State Department colleagues about 3 scenarios that could unfold in Sierra Leone and the role of accountability under each one of them. We decided to start talking privately with other Security Council members about issues of accountability, collection of evidence, and apprehension as matters to be factored into any UN peacekeeping or multinational force mandate following the kidnappings. And we knew and we needed to start discussing prospects for an international or regional criminal tribunal. The diplomacy to build the court for Sierra Leone began the next day on May 11, 2000, when I sat down with a man I so deeply respect, Hans Corell, the UN's top legal counsel, for the first real discussion about this between a United States representative and the UN Legal Council. He emphasized correctly the no amnesty provisions of Secretary General Kofi Annan with respect to the Lomé Peace Agreement of 1999 and anything that might follow now. The character of any tribunal, however, remained open to our future creative thinking. 1 week later, British intervention forces arrested Sanko and put him under the custody of the Sierra Leone government. That act signaled the possibility that if a criminal tribunal were created, at least one likely defendant already was in custody. This was very significant to me personally, because the quest to bring Pol Pot into custody in 1997 and 1998 in Cambodia was the predicate to galvanizing sufficient political support, particularly in the Security Council, for a war crimes tribunal covering the Pol Pot atrocities of the 1970s. The failure to capture Pol Pot prior to his death in March 1998 was a huge setback to that endeavor. We were constantly beset by the paradoxical dilemma of having to achieve custody first before we could gain political support to build the court that could indict Pol Pot and his colleagues, and simultaneously try to figure out how to maintain custody in the absence of a prosecuting court. But Sanko was in custody, at least in a Sierra Leone jail, and that was a very useful development. I knew we had to seize the moment for a new tribunal. I quickly sent a memorandum of possible options for accountability and justice forward to Susan Rice, then the Assistant Secretary of State for African Affairs, and to Harold Coe. I predicted that upon the safe release of the UN peacekeepers, a broad consensus could emerge to hold Sanko and other hardline RUF leaders accountable for atrocity crimes. The issue would not be whether to do it, but how. While a domestic prosecution was theoretically possible, I was deeply skeptical of the Sierra Leonean court's capabilities. The country's death penalty would make it impossible for European governments to provide expertise, funding, and logistical support, which were desperately needed. The other option would be some kind of regional or international tribunal similar to the Yugoslav and Rwanda tribunals. I suggested that any regional court, perhaps forged by the European Community of West African States, could still benefit from UN Security Council engagement in a joint enterprise of legal authority, expertise, and funding. There were basic questions, however, still to answer. How broad would the scope of the court be in terms of the individuals it could prosecute? Would just Sierra Leoneans be held accountable, or would foreign nationals such as Charles Taylor, who had allegedly committed crimes on Sierra Leone territory, also be accountable? What would be the chargeable offenses, and would there be a way to bring the blood diamond trade into the realm of criminal conduct? Would international forces in Sierra Leone have the authority to investigate and arrest suspects? By early June 2000, I began to press for a full-fledged international criminal tribunal for Sierra Leone, as that was the option I felt most comfortable with under the circumstances of a clear threat to peace and security in that country, and hence there was jurisdiction for the Security Council to engage on the judicial front. We determined that President Kaba of Sierra Leone preferred a Security Council tribunal as well. Attorney General Barrera of Sierra Leone confirmed that his country would approach the United Nations for a UN court rooted in the Sierra Leone legal system and seek flexibility about moving the trial elsewhere in West Africa if security risks so required. He wanted a Security Council resolution soon. One option was to expand the Rwanda Tribunal to absorb Sierra Leone. But several problems cropped up on that front, and we abandoned it fairly quickly, despite the fact that the U.S. Permanent Representative to the United Nations, Richard Holbrooke, would press hard for that option from his perch in New York. The kidnapping of several hundred UN peacekeepers clearly was the major grounds for stoking international support for a Security Council-sponsored tribunal, even though the magnitude of atrocity crimes in Sierra Leone for years had exceeded anything done to the peacekeepers. But the kidnapping was a direct slap at the United Nations, it angered everyone, and it had the fortunate byproduct of finally focusing attention on prosecuting the atrocity crimes writ large. The concept paper for the special court that I prepared in early June 2000 proposed that the Security Council create a special court with the power to enforce cooperation by relevant governments and with financing drawn from voluntary contributions from interested governments. It was unfortunately unrealistic to propose the type of assessed contributions that funded the Yugoslav and Rwanda tribunals, as most Security Council members, including the United States and other permanent members, and woefully few other UN member states, had told me that they had no interest in being compelled to pay for the Sierra Leone tribunal. I perfectly realized at the time how problematic voluntary funding could be, and it certainly proved to be throughout the life of the court. But I also knew that any proposal that required assessed funding would die within hours on any desk in capitals or admissions in New York. In this first planning document, the court statute blended international and domestic law. This would create flexibility in charging suspects, give Sierra Leone a greater stake in the court, and allow the court to prosecute crimes against the peacekeepers. There would be co-prosecutors, one from Sierra Leone and the other a foreign prosecutor. Initially, there would be a single trial chamber of 3 judges. There would be an additional chamber to hear pretrial motions. If more chambers were needed, then they would be appointed as circumstances required. The objective was to start with a lean and robust judicial task force. The mandate of the existing appeals chamber of the Yugoslav and Rwanda tribunals would be expanded to include Sierra Leone. The special court would sit in Sierra Leone for pretrial and trial proceedings, but have the power to move them out of the country for security purposes. Sentences likely would be served outside Sierra Leone. This contingency arose partly because when the RUF invaded any area, they first went to the prisons to liberate their militia. The alternative would be to create a maximum security prison inside the country, for which funding would be extremely difficult to raise. To garner sufficient international support, the mandate of the special court needed to be narrow, thus pointing to those, quote-unquote, most responsible and the leadership. We suspected that would limit the reach of the tribunal to a few dozen suspects. I was undecided whether the special court's temporal jurisdiction must be limited to post-Lomé violations, but suggested that the Security Council allow the mandate to continue indefinitely until peace and security was established in Sierra Leone. Such an open-ended jurisdiction might deter future crimes and was the model adopted for the Yugoslav tribunal. The mandate needed to remain silent on limiting the nationality of the suspects so that the special court could investigate Charles Taylor. He was a target for prosecution from the very beginning of our discussions to build the special court for Sierra Leone. We also had to get UNAMSIL on board to assist with the apprehensions and security for tribunal investigators and other court personnel, as well as any special offices. Finally, the Kaaba government sought our assistance in sponsoring the Security Council resolution. President Kaaba sent Secretary General Kofi Annan a letter on June 12th, accompanied by a suggested framework that triggered further consideration in New York for a special court in Sierra Leone. The Kaaba letter set the stage for serious talks in the Council, and particularly between Washington and London, the 2 permanent members with the strongest engagement in Sierra Leone. On June 14th, the British informed me that they would not commit to a Security Council tribunal like the Yugoslav or Rwanda tribunals. In fact, they wanted to stand down on any resolution and await a report by a Security Council mission to the country before determining how to structure a court with a 2-year mandate that, in their view, would transform into a regional criminal court. But Holbrooke pushed back in New York, telling the Security Council on June 20 that rough leaders must be brought to justice. He invoked Kaba's own request of June 12th and called for some form of international umbrella, perhaps as an expansion of the Rwanda Tribunal, and he urged that it be done quickly to defeat the influence of impunity over Sierra Leone's rebels. Holbrooke described as far-sighted the reservation Kofi Annan had made to the Lome Peace Agreement, leaving open international accountability for atrocity crimes, and said the United States highly approved of it. But there needed to be a vigorous international mechanism or an extension of an existing one to accomplish this, he said. In the following days, I worked through details of how the special court could be structured, including its legal character internationally and its jurisdiction. The key remained for the Security Council to establish the tribunal, even if it had hybrid characteristics with Sierra Leone participation, so that it could share the existing appeals chamber of the Yugoslav and Rwanda tribunals, compel cooperation of governments, enforce sentences, and require UN selection of key staff, particularly a lead prosecutor and the judges. Although Sierra Leone wanted to share or even chair the prosecutorial duties, we quickly realized that such a lead or co-equal role would be unworkable in New York. We already had been pushed to the wall in Cambodia on that issue, and there was no appetite to repeat the sharing model for Sierra Leone. Most council members would insist on an international prosecutor selected by the Secretary General to head up the prosecutions. But we got bogged down by late June over whether the special court would be of an international origin and character, namely created by the Security Council under its Chapter 7 enforcement powers, which was the American preference on the Council, or would be established within the Sierra Leone system with a heavy dose of international assistance, which was the British preference, despite the death penalty issue looming over that particular horizon. An innovative approach had to break the logjam. I was nearing the end of weeks of negotiations at the UN over the rules of procedure and evidence and elements of crimes for the International Criminal Court, two documents which the United States joined consensus on at the end of June 2000. During a break in the talks, I was lost in thought walking along 2nd Avenue, bound for a Dunkin' Donuts coffee, actually, when the idea struck me. If the International Criminal Court was to be created by treaty among governments, why not also establish the Special Court for Sierra Leone as an international criminal court with a treaty between the United Nations and the government of Sierra Leone? That was certainly being contemplated for the Cambodia Tribunal, albeit with a domestic court, the fulcrum of that particular treaty. Surely we could reverse the equation and create an international court with Sierra Leone participation by treaty between the United Nations and the government, and thus avoid having to use the Security Council's enforcement authority, which the British so firmly opposed, given the recent arrival of the International Criminal Court and the collective desire in New York, mostly for financial reasons, to remove the Council from tribunal building exercises. I described my approach as the co-establishment concept and began immediately to draft the language and talk up the idea back in Washington. Granted, we would lose the powerful enforcement authority of the Security Council that the Yugoslav and Rwanda tribunals benefited from, at least in theory and law, because the Special Court would not be established as a subsidiary organ of the Council as had been these other tribunals. But the proposal suggested an easier pathway towards political acceptance by skeptical and tribunal-fatigued council members and those non-aligned governments, such as Mexico and Brazil, that despised empowering the Security Council to build more courts. It also had the advantage of giving the UN Secretary General the upper hand in staffing the court with international prosecutors, judges, and administrators, and thus ensuring international control of the proceedings. This was far different from the Cambodian negotiations at the time, where Phnom Penh was insisting on a Cambodian court staffed in the majority with its own nationals. Freetown refrained from making those kinds of demands during the negotiations. But until the remaining kidnapped UN peacekeepers were released, there was little chance of making headway in the Security Council on a court-building resolution. The fate of the peacekeepers had to remain the only priority until the crisis was resolved. More delegations also were reacting negatively to yet another Security Council tribunal on the horizon. And then ultimately, the UN peacekeeper situation was resolved that summer. Harold Coe and I engaged the British government in fairly intense negotiations in mid-July to achieve an agreement on the way forward. The British wanted a domestic court bolstered with international assistance. Secretary of State Madeleine Albright called British Foreign Secretary Robin Cook, who was still smarting from the Yugoslav Tribunal prosecutor's review of NATO bombing decisions during the Kosovo campaign. Cook did not want another Carla Del Ponte to charge in as prosecutor. He refused to offer his own country as an available site for any trials that might need to be held outside Sierra Leone for security reasons. So the hard slogging between us continued. Then on July 19th, the U.S. Deputy Permanent Representative to the United Nations, James Cunningham, called me with a breakthrough. The British wanted to settle differences over the structure of the court. I immediately drafted a short concept paper, shot it up to Cunningham in New York. Within a week, word came back that the British would work on the basis of our concept paper and the text of the Security Council resolution and treaty we were working on. I flew to Freetown to nail down terms again with the Sierra Leone government. Upon my return, more negotiations followed, particularly with UN Legal Counsel Hans Corell. And on October 14th, the Security Council adopted Resolution 1315, which became the launching pad for the ultimate establishment of the Special Court for Sierra Leone. The resolution requested that Secretary General Annan negotiate an agreement with the Sierra Leone government, quote, to create an independent special court consistent with this resolution, close quote, with jurisdiction over atrocity crimes and several categories of crimes under Sierra Leone law. The Council recommended that the special court, quote, should have personal jurisdiction over persons who bear the greatest responsibility for the commission of the crimes, including those leaders who, in committing such crimes, have threatened the establishment of and implementation of the peace process in Sierra Leone, close quote. The Security Council, following Kaba's lead from his June 12 letter, requested Annan to send a team of experts to Sierra Leone to prepare a report on how precisely to establish the special court. Key issues the experts had to address included the tribunal's temporal jurisdiction, how to set up an appeals chamber, and whether to share the one used by the Yugoslav and Rwanda tribunals, which ultimately was abandoned as an idea, and where else the special court could sit if Sierra Leone proved too dangerous. The critical issue of how voluntary contributions could support the special court's operations loomed as a major challenge for the experts to address in their report, and they delivered that report on October 4th, 2000. For months following the August 14th Security Council resolution, an intensive debate unfolded between Security Council members and the UN lawyers over how to finalize key provisions of the governing statute of the Special Court and ensure they mirrored sections of the agreement to be entered into between the United Nations and the government of Sierra Leone to establish the court. For example, I spent weeks negotiating the scope of the Special Court's personal jurisdiction. The UN lawyers wanted prosecutors to go after a relatively broad group of individuals who were quote-unquote most responsible for the atrocity crimes. The United States and most of its Security Council partners wanted a smaller set of possible suspects given the Special Court's limited capacity and reliance on voluntary contributions. We also wanted to focus on those individuals who had violated the Lomé peace agreement. So Council members insisted on, quote, persons who bear the greatest responsibility, close quote, for the atrocity crimes, and that language prevailed in the final text. That doesn't mean it was the logical position. I think Hans Corell's position was probably the most logical, but that's where the politics ended up. There were humorous moments when the difference between quote-unquote most responsible and quote-unquote greatest responsibility descended into distinctions without a difference, but the dueling definitions dogged many discussions. The Security Council also prevailed with explicit reference to, quote, those leaders who in committing such crimes have threatened the establishment of and implementation of the peace process in Sierra Leone, close quote. While their crimes reached back to November 30th, 1996, we considered it was fair game for the international prosecutor to investigate those crimes, but leaders who failed to abide by the Lomé peace agreement had to know that they were primary targets for the court. Another highly sensitive issue was how to deal with the largely Nigerian ECOMOG peacekeepers, that was the regional peacekeeping force at the time, who allegedly had committed their own crimes and human rights abuses against rebel forces and civilians during their long deployments in Sierra Leone. The issue of peacekeeper liability also focused on the UNAMSL, the UN peacekeeping forces, then deployed in large numbers throughout Sierra Leone. The sending state governments had zero interest in their own military personnel falling under the special court's jurisdiction. But non-governmental organizations and the UN lawyers argued that the prosecutor could not credibly pursue only certain categories of top perpetrators while ignoring the past or contemporary conduct of the peacekeepers, be they of ECOMOG or UNAMSL identity. While logic pointed to inclusion, political reality dictated exclusion. The controversy also involved the International Criminal Court and whether troops from countries not party to that court should be subject to its jurisdiction under any circumstances. Most of the contributors of troops in Sierra Leone at that time were not party to the International Criminal Court statute, and thus did not want the special court to pretend to exercise jurisdiction the same way some were arguing the International Criminal Court should be able to if atrocity crimes were committed on the territory of a country like Sierra Leone that had joined that court. The compromise that eventually emerged held that, quote, any transgressions by peacekeepers and related personnel present in Sierra Leone, close quote, under agreement with or with the consent of the government of Sierra Leone would be within the primary jurisdiction of the government that sent the particular soldiers, meaning, for example, that the courts of Nigeria would be responsible for investigating and prosecuting Nigerian peacekeepers deployed in Sierra Leone. However, in a nod to the complementarity principle firmly lodged in the Rome Statute, the governing statute and treaty for the special court required that, quote, in the event the sending state is unwilling or unable genuinely to carry out an investigation or prosecution, the court may, if authorized by the Security Council on the proposal of any state, exercise jurisdiction over such persons, close quote. This potentially exposed peacekeepers to the special court's jurisdiction. The UN lawyers long argued that the Secretary General, rather than the Security Council, should make the determination of whether a nation was, quote unquote, unwilling or unable to investigate or prosecute. But the Security Council insisted that it retain that authority. Not surprisingly, there proved to be no political will to reach any such decision in subsequent years. The third major issue of contention involved whether juveniles under the age of 18 at the time of the commission of the crimes could be investigated and prosecuted by the special court. The Kaaba government insisted that teenagers between 15 and 18 years of age, when the alleged crimes were committed, be subject to the court's scrutiny. These teenagers often were the military gang leaders who led the mutilation and killing sprees throughout the country, and there was no willingness to show them mercy in Sierra Leone. This led to a long and intense debate, as many key governments, including the United States and UNICEF, strongly opposed any juvenile liability for the special court. The Rome Statute had recently set the liability barrier at 18 years of age. This became a make-or-break issue for the Kaaba government, similar to the death penalty imperative for the Rwandan government in 1994 that led to its negative vote in the Security Council on the creation of the Rwanda Tribunal. We finally found a compromise, one that permitted prosecution of the crime of conscripting or enlisting children under the age of 15 into armed forces or groups or using them to participate actively in hostilities. This was the recent Rome standard for that war crime. The Sierra Leone Domestic Court criminalizing abuse of young girls and their abduction for immoral purposes was incorporated as an offense in the special court statute. Children between 15 and 18 years of age could be prosecuted, but with several key caveats relating to how they would be treated and punished. There would be no imprisonment as a means of punishing such juvenile offenders. As we all know, the first prosecutor, David Crane, never charged anyone under the age of 18 when the crimes took place, so these provisions of the constitutional documents of the court never were put to a real test. The notorious amnesty clause of the Lomé Peace Agreement, which Kofi Annan had disowned after the document was signed, and Hans Corell reaffirmed when the Sierra Leone negotiating process began, was buried for purposes of the special court, and the Kaaba government never objected to the reality of having to do so. But the negotiations centered on ultimately limiting the no amnesty principle to atrocity crimes, and not to the special violations of Sierra Leone law also forming part of the court's jurisdiction. The Lomé amnesty was litigated by defense counsel in cases that came before the special court in later years, but was never successfully invoked to shield a defendant from criminal charges or conviction. And I'm almost finished. The final major contention between the Security Council and UN lawyers centered on how to fund the special court. Since it could not be a Security Council tribunal established under Chapter 7, and there was no interest among other council members, or most council members, to finance the court through UN-assessed contributions, the only way it could be funded rested on voluntary contributions of interested governments. We all knew this was far more problematic than the kind of funding enjoyed by the Yugoslav and Rwanda tribunals, but either the special court would be voluntarily funded or there would be no such court established. So we struggled for months over this key issue. Russia, China, France, and even Britain flatly refused assessed contributions or obligations, and the US Congress did not even want me to present the idea. They couldn't even imagine it. Kofi Annan refused to conclude the treaty with the government of Sierra Leone until there was enough cash on hand to finance the first year of operations and pledges covering the second and third years of work, and that was actually written into the treaty between the United Nations and Sierra Leone. And then that finally was accomplished by January of 2002 when Hans Corell signed the agreement. Everyone associated with the Special Court for Sierra Leone, including the prosecutors and Hans Corell, can tell you the nightmarish reality that followed as each year's funding had to be raised. Believe me, I feel your pain, as I am now the one scouring the globe for funds to sustain the Cambodia Tribunal's work on a month-to-month basis. But the alternative in both situations likely would have been no tribunal at all, and you can certainly argue the merits of that particular outcome. I would further argue that despite the criticism of how the Special Court for Sierra Leone ultimately performed some of its duties and the quality of some of its personnel, the accomplishments of the Special Court remained largely faithful to its original design and purpose. I'm thankful that everyone in this room who committed themselves to this enterprise did so with good faith intentions and incredibly hard work. One key element to this entire process that I have not discussed, and will only do so for a second here, is the Truth and Reconciliation Commission, which also was on deck during this time frame. In fact, discussions commenced long before those for a special court. I think it's a tribute to Mary Robinson, who was the UN High Commissioner for Human Rights at the time, and commission members like Professor William Schabas, who is with us, as well as David Crane, who worked so hard on this issue, that there ultimately emerged a fairly successful partnership between the Special Court and the Truth and Reconciliation Commission. I can assure you that in the early days, while atrocities raged, that was not easily assured whatsoever. And finally, I think I just want to close by saying we're here to celebrate the 10th anniversary of the Special Court for Sierra Leone, and I consider that to be a very happy moment. So thank you very much.
So on behalf of the American Red Cross and everyone here, I just want to say an official thank you to Ambassador Scheffer and join me in giving him a round of applause for really setting out a lot of the challenges that they've faced in setting up.
Okay, thank you very much. We're certainly looking forward to a continuing relationship with the American Red Cross, so thank you very much. A few announcements leading up to the next program. The buses will be gathering very shortly outside here to take you back to Fletcher Hall for this afternoon's program, which will begin at 2:30. I also want, for those, as I said this morning, for those of you who are not staying at the hotel that intend to join us in the evening program, please, as you're going out the door, stop at our table right there and give us your name so that we can provide the accurate number to the hotel for the evening meal. That is very, very important. And so thank you very much, and we will see you in about 32 minutes at Fletcher Hall. Thank you.